35, line 35, insert the words as printed in the Marshall list.
My Lords, I rise to move Amendment 115 and 117 to 125 in this group, all standing in my name. They have a similar approach to that set out by the noble Baroness Lady Brinton, but the focus is rather different, as I shall explain. My Lords, I should say I support the general thrust of the bill. The argument for the bill is that it creates a number of deterrents to people arriving in this country illegally. The principal deterrent, of course, is that of immediate or at least rapid removal to another country. But the bill goes further than that and also seeks to deprive those who have fallen foul of the tests in Clause 2 of their subsequent right to apply for naturalisation as a British subject, or, more crucially, and to the point of my amendments, their right to apply for registration as a British subject at any point in the future. Now, of course, noble lords are very well aware there is a great distinction between naturalisation and registration. Naturalisation is a concession by the state to those who are not British to allow them to become British, and it's perfectly natural that there should be conditions attached to it, and those conditions very often can and do include good behaviour conditions, such as perhaps, if this bill passes, not having previously arrived illegally in a small boat. But registration is not in the same category. And my first objection is to the Home Office constantly seeking to conflate naturalisation and registration. Registration is a route whereby persons who are entitled to British nationality have but where the circumstances are perhaps slightly dubious or uncertain or documentation is missing, have the right to articulate and vindicate that right and to be granted British nationality as of right. And it seems to me cruelly wrong to deprive people of that right of whatever age, adults or children, and the effect of these amendments taken together is to remove those clauses entirely from the bill, so that the right of registration, of applying for registration, would remain available to those who have it, even after they have been expelled. I do not believe that, especially given the numbers involved, that this would in any way diminish the overall deterrent effect of the bill. Now, I could, at this point, sit down, having briefly summarised what was discussed in committee, but I feel I'm going to go on a little bit to respond to my first opportunity, really, to respond to what the Minister had to say on that occasion. And I should at this point perhaps say I'm grateful to my noble friend the Minister for the time he has given to a meeting with me on this particular topic, and I should perhaps at an earlier point have said that I'm grateful to the noble Baroness Lady Lister of Bertaset for her support on this occasion as in committee. But the thrust, as I understood it, of my noble friend's response was that he envisaged a situation in which, on the one hand, most people arriving in this country in the manner prescribed would be removed very rapidly, but on the other, some might stay. There might be reasons for them to linger, and in doing so, they would accumulate residence rights in this country, and residence being a condition for some routes to registration, they would get in, so to speak, by the side door, simply by being here on these shores over a fairly prolonged period. But I did want to say that I do think my noble friend has misunderstood what is happening, because the routes to registration that are set out in these clauses, and which my amendments would remove, have nothing to do with residence at all. For example, sections 5, 10.1 and 13.1 of the British Nationality Act 1981 are each included amongst the entitlements that are caught by Clause 31.1 of this bill, but none of these provisions has anything to do with residence. None of the registration provisions caught by Clause 31.2 include any requirement of residence. Moreover, Section 3.2 of the British Nationality Act, to which the Minister made particular reference, applies to children born outside the UK to a British citizen by descent in two distinct circumstances. The first is where the child is stateless. In this instance, there is no requirement concerning residence of anyone. The second is where the child is not stateless, and in this instance, there is a requirement of previous residence of the British citizen parent, someone with a clear right of entry and residence in the UK, and no requirement of residence upon the child. There is simply nothing of the explanation offered by the Minister concerning residence that could apply to either of the circumstances in which Section 3.2 entitles a child to British citizenship. And similarly, we could refer to Section 3.5 of the British Nationality Act. This concerns children born outside the UK to British citizens by descent. This does require some period of residence of the child with their parents in the UK. To fall foul of this bill, the child be brought by their parents, at least one of whom is a British citizen, to the UK. And the most likely circumstances in which this entitlement, or indeed that under Section 3.2, might ever come to be barred by this bill would be if the British parent of a child mistakenly thought that, like them, their child was already a British citizen by birth, or at least did not require permission to come into the UK with them. The second point I want to make in response to what my noble friend said is that he was quite clear in response to a point raised by the noble Baroness Lady Chakrabarty in rejecting any implication that the intended exclusion of a child's citizenship rights was based upon any notion of a child's culpability. Now, that, of course, is very welcome. This entirely proper disavowal of culpability but raises a more profound question as to the motivation for barring the child's citizenship rights. This is because what is the explanation? If it is not the child who is culpable, who is culpable? Who is being punished, and for what reason? And it may be possibly the parent, but the Minister, my noble friend, needs to make clear what it is he thinks he is achieving by that. And if it is not the culpability of the child, who then is it? Now, there are further points I could make, but I will rest at that point and simply say that although I don't intend to press this to a vote, I do hope that I can hear some consolation and comfort from my noble friend, the Minister. The number of people involved in this case in these circumstances is almost certainly likely to be very, very small. And the deterrent effect, it seems to me, of the bill is not diluted by this. But this conflation of registration and naturalisation that the Home Office adheres to is exactly the sort of sloppy thinking which underlay the Windrush scandal. And there will be scandals, potentially, even if individual ones, rather than great numbers. But there will be scandals as a result of this. And I would urge my noble friend to take this opportunity to think again and to remove registration from the deterrent elements of this bill.